When is a contract breach considered material in business? Imagine signing an agreement that promises you a product or service, only to find out the other party failed to deliver something essential. That's when a breach of contract becomes more than just a small hiccup. It's considered a material breach. A contract breach is called material when one side doesn't perform a key part of the deal that really matters to the other side. This kind of breach can seriously hurt the benefits you expected from the agreement. If the breach is big enough, you might be able to end the contract or ask for damages. So, how do you know if a breach is material? First, look at what part of the contract was broken. If it's something central, like delivering critical goods on time, that's a sign it's a material breach. For example, if a supplier misses a deadline for parts needed to keep a factory running, that's a serious problem. Next, think about the harm caused. If the breach causes big financial losses or stops your business from working properly, it's likely material. If it prevents you from getting what you paid for, that's a strong indicator. Another factor is whether the breach can be fixed easily. If it's something minor that can be corrected with a quick fix or compensation, it's probably not material. But if the breach defeats the purpose of the contract entirely, it is. Courts also consider what the parties reasonably expected when they made the deal. If industry standards say that timely delivery is essential, missing that deadline could be a material breach. Lastly, if several small breaches happen over time, they might add up to a material breach. When multiple minor issues combine to significantly reduce the value of the contract, the non-breaching party can consider it serious enough to act. Recognizing a material breach is important because it affects what legal options are available. If a breach is deemed material, you might be justified in ending the contract and seeking damages. Many contracts specify what counts as a material breach and what remedies are available, helping both sides understand their rights clearly. Examples include a construction company delaying work for beyond the agreed date, a service provider not meeting the promised standards, or a supplier delivering defective goods that disrupt your business. To prove a breach is material, you need to show that the breach had a serious impact on your benefits and that the other party failed to fix the issue. This way, it's clear that the breach isn't just minor or technical but truly undermines the purpose of the contract.